The mix on this, Senator Angus King, an independent from Maine, serves on the Intelligence and Armed Services Committee. It's good to see you, as always, Senator. A couple of topics for discussion today. People keep referring to the Constitution. This isn't really about the Constitution. We know the president has authority and is really, the word is shall in the Constitution, that he is supposed to nominate someone during his term. What's going on here?
Well, of course, what's going on here is a lot of politics, Chris. There are a lot of words and phrases in the Constitution that you can argue about that are subject to interpretation, long, windy law review articles, court cases, but 4 isn't one of them. The president serves for a term of 4 years, not 3 years and 1 month. And I think the president has a constitutional obligation to nominate somebody, and the Senate has an obligation to take it up. You pointed out that the Article 2, Section 2 says shall. The president shall nominate. We've got an opening on the court. I think Sandra Day O'Connor made a very practical point. Let's fill the vacancy so the court can fully function and get on with it.
Country is split on this. Country is split on everything, and the split is down along the partisan lines as expected. The feeling is the best case scenario here is President Obama nominates somebody and the Republicans decide to have hearings, but there's no way he gets the thumbs up on anyone he picks. Is that what it seems like to you?
Well, you know, that's what I'm hearing, but I'm surprised people can make that judgment before they even know who the nominee is. I mean, it may be somebody that, for example, one of the recent nominees to the D.C. Circuit got voted 97-0. So it may be that he picks a nominee that's so eminently qualified that it would be very hard to explain a vote against them other than politics. So, you know, I keep hearing that, but there was this rush of comments in the first couple of days. We're not going to hold hearings. We're not going to vote. We're going to delay. And some of the folks have sort of moved a little bit back from that as I think people have calmed down a little bit. But again, this is a pretty straightforward provision of the Constitution, right, and I like to fall back on what that says.
Right, but you know, there is this, I don't know, I don't want to be too strong about it, but there is this ruse, let's say, that, you know, you pick a judge who's kind of down the middle and you don't know where he or she really is politically, and just not true. I mean, look who we're replacing, Antonin Scalia. He worked for Ford, he worked for Nixon. You know, the politics were there. Sandra Day O'Connor. Is it really a surprise that she's supporting the Democratic president's proposition on this? These are political people you wind up putting in these positions. Is it time to just drop that pretense?
I don't think it's fair to characterize Sandra Day O'Connor. She was a Republican. She was appointed by a Republican president.
But you know where she was on the court. You know where she seemed to be.
Yeah. Yeah, she was generally a swing vote, but you know, of course we have these debates, and of course there are politics involved, and where the position of the judges are is important. But you know, how we proceed on something like this. Back in 1991, Clarence Thomas was nominated. There was huge opposition. There was huge support. There was pressure on both directions. George Mitchell from Maine, by the way, who was the majority leader at the time, refused to mount a filibuster. Clarence Thomas was confirmed 52-48. And Mitchell could have stopped it. He could have put a filibuster in. He was under pressure to do so. He said that's not the right thing to do, typical of George. And we went ahead and had a vote. And, you know, that's the nature of our system. People say, well, the president should decide, the people should decide. Well, the people elected this president a little over 3 years ago.
But the politics work both ways.
It's his call.
The politics work both ways on the Senate.
And they ought to work both ways. I agree.
Well, but that in this current situation would militate in favor of locking up the process. We all know what Chuck Schumer said back in 2007. You now have President Obama saying he regrets that he voted for a filibuster on the Alito nomination when he was a senator. This is what these guys do. You're right. I'm not painting Sandra Day O'Connor as a lefty. I'm just saying that the people who they wind up putting in place, it's all about politics, and it always has been. Why create a different standard now?
Well, there have been I did a little homework yesterday. There have been 8 Supreme Court justices approved, 8 nominated in election years, 6 approved since 1900. The last one was in '88 at the last year of Bush's term. Anthony Kennedy, who, by the way, wrote the Citizens United opinion, he was confirmed in the last year of Reagan's presidency. So, the precedents go both ways. Of course, you're right. The politics are important. And I'm not saying that a Republican senator has to vote for whoever Obama nominates. I mean, I would never say that, but I do think just saying we're not even going to have the process, we're not going to hold hearings, we're not going to vote, we're not even going to let it come to the floor. It would end up being more than a year. I think it's pretty troublesome.
Give me a quick take on what's going on with Apple. Where do you think the line is between what you require a company to do when it comes to helping law enforcement?
Well, I think a company has to respond to valid subpoenas and warrants. On the other hand, we ought to be clear what the FBI is asking Apple to do in this case. They're asking Apple to modify their own software. They're asking Apple to create a key that does not currently exist. And I've got a real problem with that. This is a very complicated issue. We've been talking about it in the Intelligence Committee with Mr. Comey, the head of the FBI, for over a year. Everyone concedes that this is very complex, and to suddenly go into a single federal district judge based on a 1789 All Writs Act statute strikes me as the wrong way to try to find this balance. It's not an emergency. I think this is one that's going to take a lot of debate. There are a lot of problems with this. If the FBI in this particular case can make Apple open up this phone, what's to stop a DA in North Carolina on an OUI from doing the same thing, or somebody in a burglary in Oklahoma? It's a serious precedent, and there's an old saying in law school: hard cases make bad law. And this is a hard case. It's a terrorism case, but I don't want to see law made that would open up the personal information of every American to the government. Or once that key is made, it can end up in the hands of hackers. I mean, then what if China says, well, if you're going to sell iPhones here, you got to do the same thing? What if this were Samsung that's based in South Korea? Could a U.S. court tell them? I mean, there are no end of complications of this, and so I think we need to slow down and really consider the policy. This is not something that I think we're going to be able to solve in a single action in a district court in California.
Articulating well the slippery slope involved here, Senator Angus King, independent from Maine. Thank you as always, sir. John.